Please be seated.
All right. Welcome and thank you to everyone joining us here, friends, family, colleagues, and alumni, for joining us for today's ceremony. My name is Kathleen Haggerty, and I'm Northwestern Provost and the first Chicago Professor of Finance at the Kellogg School of Management. I think normally the dean would be the emceeing these ceremonies, but the dean tonight is one of the honorees, so I'm playing that role tonight. It is such a pleasure as we celebrate the investitures of Zach Clopton, Myriam Gilles, Paul Gowder, Gilles Horwitz, and Alex Lee. Endowed professorships are one of the ways the university recognizes its most distinguished faculty, and each of the recipients tonight is a leader in the field of law and brings distinction to Northwestern with their scholarship. The Pritzker School of Law plays a particularly important role in society, training future practitioners and scholars of law. We need these champions and protectors of our legal rights. Now, I'd like to share a bit about today's honorees, and each of whom will deliver remarks this afternoon. Additionally, I will say a few words about the influential and generous people who made these professorships possible. So first, Zachary Clopton is the Interim Dean of the Pritzker School of Law and the Daniel Hale Williams Professor. Zach is a nationally recognized scholar in civil procedure, complex litigation, and international litigation. His recent scholarship has appeared in the Yale Law Journal, the Stanford Law Review, NYU Law Review, University of Chicago Law Review, Michigan Law Review, and the California Law Review, among others. Daniel Hale Williams, who this chair is named after, became the first African American to receive an MD degree in the Chicago Medical School, which became the Northwestern Medical School. A founder of Chicago's Providence Hospital, Williams was a pioneer in the efforts to establish professional and professionalize institutions to train and develop Black physicians and nurses. Myriam Gilles joins the faculty of the law school as the Catharine Waugh McCulloch Professor of Law, after serving on the faculty of the Cardozo Law School, where she held the Paul R. Burkle Research Chair in Public Law. She teaches and writes in the area of civil procedure, complex litigation, and torts, and is currently the 5th most cited civil procedure scholar in the country. Her professorship was established to recognize Catharine McCulloch, a lawyer and suffragette who lived and worked in Evanston during the time of social change. In 1886, she graduated from Union College of Law, which is now the Pritzker School of Law. Now, Pritzker in the late 19th century had a number of extremely interesting alums, and she was among them. So she was the first woman in Illinois to be elected to be, Justice of the Peace. Now, this was particularly interesting because when she was elected, women in Illinois did not have the right to vote. So, and she also ran for state attorney when women did not have the right to vote. She lost that one, but she won this one. She was also largely responsible for the passage of the 19th Amendment in Illinois, and I think as many people know, Illinois was the first state in the United States to ratify the 19th Amendment. So she was an extremely influential and interesting person. Paul Gowder is the Frederic P. Vose Professor of Law. Paul joined Northwestern Pritzker Law School of Faculty in 2020. He is a well-known scholar of the rule of law. He has taught a variety of classes, including constitutional law, torts, and professional responsibility. His practice days, he was a civil rights and legal aids lawyer. His affiliations include the Global Rule of Law Commission of the European Public Law Organization and the American Law Institute. The Vose Chair was established in 1966 through a request from Lucy Mason Vose in memory of her husband, a Chicago attorney and member of the class of 1894. Gilles Horwitz joins the Northwestern Law School as the Trobman Innovative Professor of Law with the joint appointments as a Professor of Emergency Medicine in the Feinberg School of Medicine. She recently served as the Jack N. Pritzker Visiting Professor of Law at Pritzker. Her research and teaching portfolio includes health law and policy, nonprofit law, and torts. She is a research associate at the National Bureau of Economic Research and was previously the David Sanders Professor of Law and Medicine at UCLA and a Professor of Law at the University of Michigan. The Trobman Professorship was established in 2023 through the generosity of Richard N. Trobman, JD 91, and Sandra Trobman to provide support for interdisciplinary scholar whose work bridges the law-STEM interface and/or helps to advance needed innovation in law. Rich, who's chairman and managing partner of Latham Watkins, is here today along with his wife, Sandra, and we are so pleased to to have the honor for them to be present on this special occasion. So thank you very much. Where are you? Here. Alex Lee is the Howard Friedman Professor of Law. Alex teaches security regulation, business associations, and administrative law. His research interests include cost-benefit analysis, law and economics, litigation and settlement models, theories of regulation, and consumer protection law. He previously taught at the USC Gould School of Law. He also served as senior counsel in the Division of Risk, Strategy, and Financial Innovation for the U.S. Securities and Exchange Commission. The Friedman Professorship was established in 2022 by Linda Friedman Meadow, BS 98 and JD 92, and Carrie Meadow in honor of Linda's father, Howard Friedman, a 1964 law school graduate. The Friedman Professorship has a focus on transactional law in the areas of real estate, tax, or corporate law. Linda has joined us today. Linda, where are you? Pardon me? Oh, we're playing it. Well, that's understandable. So this is maybe later. Okay, great. And well, she's not here, but if she was here, I would thank her and her family for their generosity. I also want to recognize Hari Afskoski's role in the Trobman and Friedman professorships and for her leadership as dean. So thank you, Hari. We are so, we are so grateful to our generous supporters who make the investment in our faculty and the university. It is investment like yours in endowed professorships, and specifically in the incredible scholars like the 5 we have up here today that ensure that Northwestern remains a leader of essential legal work and scholarship across the country and indeed around the world. Now comes the highlight of the afternoon, which is getting to hear from our honorees. So each of our honorees will be introduced by an esteemed colleague and friend of the law school. At this time, I'd like to invite Marty Reddish to the podium to introduce Zach Clopton.
I am truly honored to have been asked to introduce Zach Clopton as the Daniel Hale Williams Professor of Law. It is a form of recognition which Zach richly deserves. It is by no means an overstatement to assert that Zach is among the elite group of young procedure scholars who will dominate the field for the next generation. His accomplishments in the field are many. Zach has authored numerous scholarly articles in many of the nation's most prestigious scholarly journals. He is co-author of the prestigious Civil Procedure Casebook, authored originally by famed Harvard Law School scholars Benjamin Kaplan and Richard Field. On top of all this, Zach is among the most beloved teachers on the faculty. In recognition of his many impressive accomplishments, Zach has been honored in multiple ways. He is a member of the National Law Institute, but he is also recognized by his appointment by Chief Justice John Roberts to serve as academic member of the Federal Rules Advisory Committee. This is among the greatest honors that a civil procedure scholar can receive. Most impressive about all this is the fact that he's achieved it while he is the equivalent in academic terms of a teenager. The honor he receives today is the natural outgrowth of all he has accomplished to date. But I would be remiss if I failed to mention the proverbial elephant in the room. Zach is not only the Daniel Hale Williams Professor of Law, he is also the interim dean. And on that point, I must confess a small degree of mixed feelings. Please do not misunderstand. Quite literally, the minute I learned that the deanship had become open, I sent a message to the university president strongly recommending Zach for the position. And I think he's here and he can confirm that. Zach brings numerous important qualities to the deanship: strong scholarly values, wide experience in law school administration, and a personality absolutely no one can dislike. Why then do I express mixed feelings at his ascendancy to the interim deanship? Because the burdens of the deanship usually prevent normal people from continuing either their teaching or scholarly activities. And if that were to happen, as it often does, although the law school would be gaining a great deal having Zach as dean, it would simultaneously be losing one of its best scholars and teachers. Would that he could somehow clone himself so he could serve in both capacities. for it would surely take two Zach Cloptons to accomplish all he is achieving as dean, scholar, and teacher. But perhaps there is no reason for my concern. It was recently brought to my attention by our mutual friend and Zach's co-author, Nadav Shoked, that while handling all of the numerous problems of the deanship, Zach is actually at work with Nadav on production of yet another frontier scholarly article. So maybe even without cloning, there already are two Zach Cloptons. And I am honored to call both of them my dean, my colleague, and my friend. And one final note to Zach. Zach, as the senior member of this faculty, having been here longer than anyone else, I have gotten to know many deans, and you are becoming part of a wonderful tradition. You have a lot to live up to. Some of them are gone, some of them are in this room, but they've all contributed to making this school the great place that it is. And I have no doubt you will continue that tradition as well. So, ladies and gentlemen, it is both my honor and my privilege to introduce to you the Daniel Hale Williams Professor of Law and Interim Dean of Northwestern Pritzker School of Law, the two Zach Cloptons.
No, this right here. All right. Great. We did it. Thank you, Marty. Thank you all for being here. Special thanks to Provost Kathleen Haggerty, to the Trobmans, and in absentia, the Friedman Meadows, and the other generous donors who have supported these chairs. And to my predecessor, Hari Asofsky, for her efforts in cultivating and filling them. It's truly an honor to receive the Daniel Hale Williams Professorship, and even more so to have it presented by my colleague and friend, Marty Reddish. In my new role, I spend a lot of time talking to alumni, and it is amazing how often Marty's name comes up. He is not only a leading scholar, but a beloved teacher and someone who is in the memories and the day-to-day life of so many lawyers across the country. I was also excited to note that the first 4 members of the law faculty who will speak to you tonight are civil proceduralists. Along with our colleague, Assistant Professor Monica Haymond, I think it's clear that we have absolutely the best civil procedure faculty in the country. It is truly an embarrassment of riches, and it is an honor to be a part of that group. I think it also really fits with what Northwestern Pritzker School of Law does more broadly. When I talk to alumni and employers, what I hear is that Northwestern just produces great lawyers and legal professionals. We are the lawyers' law school. And civil procedure, I think, is the lawyer's area of law. So when people think about great lawyers, when they think about civil procedure, they should think about Northwestern. They think about Marty and Jim and Monica and Myriam, not to mention the countless lawyers and judges who teach on our faculty, the leading clinics at the law school who are working on pressing issues of law and teaching our students how to be lawyers. And no, I used to be a lawyer, but I feel so much more at home as a law professor. Reading and writing and thinking are just great ways to spend the day. And I love being part of an intellectual community like the one here at Northwestern Pritzker School of Law, where we all have our own academic obsessions, but we can bring those obsessions together and revel in them as a group. I've so much I could say, but I'm mindful of the time and the long list of speakers ahead of me. And you know that I'm someone who likes to stay on schedule. So I will be brief. I'll just say this. I'm very proud to be your dean, but I promise that deaning won't stop me from continuing to be a scholar. As Marty mentioned, I've been annoying Nadav over the last couple days on changes to our new project, and I will bother many more of you with drafts of papers in the months to come. I also think that scholarship, and legal scholarship in particular, can and should have effects beyond academia. I think there's a real connection between legal scholarship and the practice of law and legal policy, perhaps especially in fields like civil procedure. So the work that we do, our audience is not just academics. It's lawyers and judges and policymakers and more. And that's why many of us seek out opportunities to apply our scholarships outside of the walls of the law school. Finally, I would like to thank my wife, Catharine Kinsler, who is here today. Katie has played many important roles in my life, including a very important roles in the early days of my scholarship, when I would ask her / make her read drafts of papers before I submitted them to law reviews. And the theory was she had lived with a lawyer long enough that she was basically a second-year law student, exactly like the editors who make decisions on law review submissions. So she was the perfect mark for those papers. But the bad news is she's now lived with a lawyer long enough and read so many of those papers that she has graduated beyond the 2L status. So I'm looking for a new victim to read early drafts. Thank you all again so much for coming here today, for your confidence in me, and I look forward to continuing to work with all of you. And with that, I think I'm handing things over to my dear friend and colleague, Jim Vander.
Well, I'm just delighted to introduce Myriam Gilles, the Catharine McCulloch Professor of Law. Together with the newly chaired professors we also recognize today, Myriam promises to transform the Pritzker School of Law. I don't want to put too much pressure on Myriam. She's a dear friend and colleague, but she does all things law professor exceptionally well and does them with a gentle spirit that graces everyone she touches. She'll make Northwestern a more lively, humane, thoughtful, and engaging place to teach, learn, and write about the law. Let's start with Myriam's impeccable record as a law professor. Harvard for college, Yale for law, and then a short stint at the noted litigation finishing school, Kirkland and Ellis, before beginning her teaching career at Cardozo in New York. Once there, Myriam compiled a remarkable record of scholarship, teaching, and service. You can't do sophisticated work in the law of arbitration or complex litigation or civil rights without having to reckon with Myriam's work. No wonder then that she's among the most highly cited civil procedure scholars in the country. And as for teaching, let me say that Myriam has won teaching awards multiple times. Best first-year professor, best all-around professor. She's even won prizes for service, if you can imagine such a thing. And she served hard time as associate dean. While her former colleagues will miss her dearly, they may take comfort in knowing that at least now they'll have a shot at winning a faculty award as well. Some of you may secretly suspect that citation counts and awards and prizes don't fully measure professorial excellence. For those doubting empiricists in the crowd, I've rounded up a few firsthand witnesses who will testify, beginning with the comments of Steve Burbank at Penn, a famously tough judge of scholarly excellence. Steve: I have followed Myriam's career with interest for years, engaging with her scholarship in areas of mutual interest, assigning her articles to my students, and seeking to emulate the habits of mind that make her such an interesting and influential scholar and public citizen. Those habits of mind include optimism, tempered by attention to history, faith in the power of government and more generally of collective action to enhance individual well-being, and skepticism about the power of unregulated individualism to enhance societal well-being. Among Myriam's many contributions to procedure literature, those which have seemed to me most important have been her articles showing how class actions can remain a vital force, both compensation and deterrence, and relatedly, her sustained and powerful deconstruction of the current law governing consumer arbitration. I join you in celebrating a superb scholar, teacher, and colleague. Or consider this characteristically trenchant note from Judith Resnick at Yale. She's wonderful. Rich Freer, the dean at Emory Law School, describes Myriam as an unquestioned leader in the field of federal arbitration. An envious California proceduralist puts Myriam first on my list of dream lateral hires. I could multiply these examples by recounting the comments of colleagues and friends who've stopped me at conferences here and there to congratulate us on Myriam's recruitment. Here's a sample. How'd you pull that off? You guys are so lucky. Incredible, just to mention a few. I was harder pressed to collect student testimony from Cardozo, but consider this from a notably reliable source, Rate My Professor. Gilles is brilliant. She's truly amazing. And it's great to take a class from her. She's wonderfully accomplished. Her class is difficult. The final was the hardest test I've ever taken, but she's incredibly fair and wants her students to succeed. Collegiality? Myriam excels in that department too, as one of her former colleagues explained to me. We made it through a lot together, crises both within and without the law school, beloved colleagues leaving, personal struggles. She was one of 2 or 3 colleagues who I could trust to help me through anything, personal or professional. I also knew that whenever I walked into her office, she would tell me kindly when I was full of BS. I'm not sure what we need more here at dear old Pritzker. Supportive colleagues or colleagues willing to call us on our BS. In Myriam, happily, we get a twofer. So yes, Myriam will transform Northwestern. We will all surely benefit from the many individual contributions she will make here, scholarship that extends and deepens legal knowledge, teaching that profoundly shapes the lives of her students, acts of service that model effective citizenship in a collegial environment, not to mention the kindness and generosity that infuse her work and interpersonal relationships. Her very presence here will encourage all of us to bring our best selves to the Academy every day. Hold your applause until I perform Livery of Season by placing the ceremonial medallion around Myriam's neck. Myriam?
Thank you, Jim, for those very, very generous remarks. It's a little bit like, here's your life, in 10 minutes from Jim Vander, which is an interesting thing. It's very humbling to hear all of these wonderful words. So I thank you so much. And I thank all of you for being here. I promise to keep it brief. I know we've got many more people to speak, and I heard the bagpiper might come back if I go long. This is an extraordinary honor to join Northwestern's faculty, to be welcomed with such warmth, a little drama, but also lots and lots of warmth, and to now hold the Catharine Waugh McCulloch Chair. I am very grateful, and I'm also very aware that I now have to live up to all of this, right? Jim talked about the things I have done. Well, now I've got to keep doing and doing even better. Because to my mind, chairs are not simply these wonderful honors, they're responsibilities, right? A chair is an investment in ideas, in the belief that scholarship can shape law and maybe even public life, right? An idea that's not always so popular these days, but that is popular in this building and is important here. And to hold a chair named for McCulloch, as the provost mentioned, I mean, I've been reading up on this woman. She was amazing. She was a trailblazer, no doubt. But she didn't just, and she was a trailblazer in a profession that was not built for her and was not welcoming to her. But she didn't just carve a space for herself. She widened the doorway so that others could follow. And I want to try to bring that forward. I'd like to think of my work in procedure. I'm the 4th proceduralist that, as Zach mentioned, that you'll be hearing from. I like to think of my work in procedure as asking how procedure can widen the public's path to justice rather than narrow it. When I read about Catharine McCulloch's life's work, it resonates and echoes with some of my own work, some of the questions I ask. Who's in, who's out, who belongs, whose legal rights matter, whose voice counts, who gets a place at the table. These are all issues I don't need to tell anybody in this room about. These are issues that this faculty writes about, thinks about, and that's part of what makes this place so special. This is a community of deep thinkers, and I am so honored to be part of it. And I just want to end with a few brief thank yous. First, to the civil procedure faculty, Marty, Jim, and Zach. Thank you for supporting me, and it is such a privilege to even be in the same line as you, in the same breath as you. So thank you so much. I do think we have the best procedure faculty in the country at this point. To the many other faculty who've warmly welcomed me, thank you so much, and I hope to meet many, many more of you. To Hari for hiring me, thank you so much. To the other chairholders being honored, such a wonderful moment to share with you. We'll always have this, so that's a wonderful thing. And finally, to my family, my husband, Gary, who's here, thank you for all the support all of these years, and for agreeing long ago to follow me anywhere once the kids were all grown. Now, I don't think by anywhere you meant Chicago in January, but it's going to be great. We're going to have a great adventure. I feel lucky to do the work I do. I feel luckier yet to do it alongside such brilliant colleagues, and extraordinarily fortunate to now do it at Northwestern. So thank you for this honor.
Well, I am honored to introduce my friend and colleague, Paul Gowder, at his installation as Frederic P. Vose Professor of Law. He writes a lot. I'm actually only going to talk about one thing that he ever did. The one work that everyone, non-specialists, all of you in this room, everybody ought to know about, his amazing 2016 book, The Rule of Law in the Real World. So legal philosophers talk about what law is for, and there's a range of accounts of what law is for. It makes the state's actions predictable, it coordinates our activities, it does justice between individuals, it justifies the coercion of the state. And so this is an ongoing discussion among philosophers of law. And there's also a puzzle about what do we mean by the rule of law? Philosophers and lawyers focus on predictability and stability. And empirical social scientists offer a cluster of indicators. The World Bank has a measure of rule of law that lumps together intellectual property protection with the speed of dispute resolution. And very often, the rule of law is assimilated to the protection of property rights. Paul showed what's wrong with all this. He writes, I'm going to quote him a couple of times, those desiderata would be satisfied by a capitalist tyranny that protects the property rights of the elite and promotes economic development while conducting a reign of terror featuring disappearances, show trials, and similar markers of a 20th century failed legal system. Paul's core claim is that the rule of law isn't centrally concerned with liberty or economic development, but with equality, the equal standing of all members of the community. And that minimally means regularity, consistent deployment of state power, and publicity. The regularities are known to the subject population. And regularity and stability matter because they provide protection against hubris, the unaccountable use of power, and terror, the unpredictable use of power. Hubris and terror can only be avoided if the masses have institutional means to coordinate in order to defend themselves against these abuses. Regularity and publicity are insufficient. I'm going to quote Paul again. To build a legal system that's regular, public, and general is to set the state on a course in which its overwhelming power is to be used against the people in the community only when those who wield it can explain to the satisfaction of a watchful public how its use is consistent with the equal standing of those against whom it is to be used. To establish such a system is to declare a commitment to equality. To maintain it is to rely on that commitment across the political community. This is a major breakthrough in legal philosophy. It has an important implication for judging the development of legal systems. It means that the rule of law doesn't require any specific institutional arrangements, doesn't need constitutions, doesn't need juries, doesn't need independent judiciaries. England had the rule of law for centuries with no written constitution when Parliament was supreme. Property rights and a free press matter because they are means of dispersing access to power. The question is whether you actually have that. The book ends with a critical engagement with the international development literature. And Paul argues that instead of pressing developing countries to create Western-style legal structures, development organizations should try to build commitment to egalitarian institutions, working with whatever norms and practices of constraining political power are already in place, in order to give larger numbers of people moral and strategic reasons to support those institutions. I'm going to give him the last word again. The rule of law will exist and persist only if the members of a political community can see how it preserves their equal status and are able to commit to coordinated enforcement of the law against the powerful. Paul richly deserves this, and I congratulate Northwestern Law School for its excellent judgment in giving it to him. Come here.
Thank you so much, Andy, not just for that incredibly generous introduction, but also for giving me the excuse to be slightly norm-breaking and mostly say things that are substantive. Because you might have noticed that it's a really interesting time to be someone who writes about the rule of law. Lately I've been thinking about how the greatest fear of academics is irrelevance, being called out by John Roberts for writing about the influence of Immanuel Kant on evidentiary approaches in 18th century Bulgaria. But, to my junior colleagues who are worried about irrelevance, be careful what you ask for. If your work is too relevant, it becomes arguably incompatible with the scholarly way of conducting oneself. The world shifts under you between one draft and the next. You're continuously distracted by needs from the press, the public, from practitioners. Anything you publish is obsolete by the time it hits print. I thought I'd learned my lesson when I published a book about technology platform governance in 2023, a book sent to the publisher a year late because fun things were happening like the acquisition of Twitter as I was writing, but the universe is currently having its little laugh about the rule of law too, and so I'm starting to take it slightly personally. But in all seriousness, as a scholarly concept and as an empirical one, what's interesting to me is that this rule of law idea that we're all invested in the enterprise of law professoring sort of sits at the intersection of jurisprudence and political science. One of the perennial debates in the law is between lawyers and political scientists about the extent to which law matters for its own sake, as opposed to just being a proxy for ideology. And when we think about this debate in terms of our rule of law ideals, I actually think we can transform it. And we can transform it by inviting ourselves to not just look at the behavior of lawyers and judges and high politicians and law professors and other elites, but also to look at ordinary people. So, one more little norm break. Just look around. In one sense, in the United States right now, there are extreme challenges to the rule of law afoot, and we all know what they are, especially in the home of this fantastic institution of Northwestern, namely the city of Chicago, as well as the city of Evanston. But even though I think that we're aware of those challenges. We also have to be aware that in a lot of ways, the rule of law is holding. When the courts enjoin some behavior by the government, these orders are frequently, not always, but frequently, even more often than not, obeyed. Kilmar Abrego Garcia made it back to the United States. Some of Harvard's federal grant money is flowing. The Texas National Guard is not yet marching down Michigan Avenue, at least not as of, the last time I looked at my phone. But this is a puzzle, right? Because I think it's easy to think, and the attitudinalists in political science would have us think that the Supreme Court doesn't much care about the content of the law, and those who have been thinking about the shadow docket may agree. Many people would suggest that the executive branch doesn't care about the law. So why is it still working? It seems to me that the most plausible answer has to go through ordinary people. There's still a cost to doing things like ignoring lower court orders because non-elites, people who aren't in this room, ordinary citizens, street-level bureaucrats, mid and low-level public servants who have to implement orders, do care about law as such and are unwilling to cooperate, at least to some degree, with its open disregard. But what does that mean if, those of us who, by any measure, are among the legal elite, have a different conception about what the rule of law is doing than ordinary people? Is it a kind of noble lie in Plato's sense, even if those of us in the know don't really believe in it these days? Do we attempt to generate its benefits by convincing everyone else that it's real and valuable? If that's true, is the rule of law scholar a propagandist? My dear friend Andy's been doing this writing about rhetoric and the value of rhetoric in the law. And, one of the reasons that I was so happy to have the honor of his introduction is because, he and I talk regularly, and I find myself going to his work to try to make sense of what precisely the enterprise of being a legal scholar who thinks about these things in a time of crisis really amounts to. And that's the true joy and beauty of our academic community, is that we're a place where these questions can be wrestled with both alone and collectively. Thank you.
I'm very pleased to be at this chair ceremony celebrating the installation into chaired professorships of several cherished colleagues, all of whom have earned this high honor. It is likewise great to see many friends of the law school joining us here this afternoon. Before introducing my friend Gilles, I want to begin with a special thanks to Rich and Sandra Trobman for their extraordinary generosity in endowing this chair in law and innovation. Also, Rich, please know that I haven't forgotten about the 20 pounds I owe you from our meeting in London nearly 10 years ago when I needed cab fare. By my count, it's up to about 26 bucks these days on the currency market, and rest assured, I will get you the money, though the fact that you have had to wait for a decade might warrant some skepticism on your part. It is my special pleasure to introduce my friend and colleague, Gilles Horwitz, the recipient of this prestigious chair, which bears the Trobman name. I'll leave to Gilles to explain how she and I first met, and I will spoil her story only by saying that it is a great example of how innovation, and in this case, a deep friendship growing in the academic space, often begins with curiosity and collaboration. Gilles is, as you know, a remarkable teacher and scholar, one who has had a distinguished professional career, beginning with academic study at Harvard and continuing through two important stints at esteemed law schools, the University of Michigan, and UCLA. These stints included not only valuable teaching and scholarship, but also service. In the case of UCLA, service in the relentless and often thankless role of vice dean. Her scholarly work is cited and relied upon by a myriad of folks in law and public policy, including judges and legislators, as well as captains of industry and of NGOs. In short, her robust and increasingly influential career illustrates how an inquisitive and exceptionally adept academic can make both scholarly and real-world impacts. This is another reason why she is very well suited to an appointment to a chair in law and innovation. So far as I am personally concerned, if Jill and I had forged our scholarly collaboration and our friendship while she continued her career in Southern California, I would say in the Jewish tradition, Dayenu. And yet this was in fact not enough for us here, so we were able to devote our energies as a faculty and under Dean Haryosovsky's leadership to recruit Jill Horwitz to Northwestern just over a year ago. It has been a match made in heaven, or at least here in Streeterville. And in this short time, she has enriched our academic community with her extraordinary scholarly acumen, her superb teaching, and personal warmth and sense of humor. I had wicked sense of humor in the original one, but I thought it would be wrong. But then, of course, I mentioned it. So her wicked sense of humor. Okay, sorry. I should note also that Jill's truly interdisciplinary training and cross-field reputation has been acknowledged here at Northwestern by her appointment in two of our schools, the law school, of course, and also the Feinberg School of Medicine. Apparently, her appointment at the medical school, as the provost mentioned, is in emergency medicine, a fact that I trust is more titular than actual, and so I'm looking at our provost when I say that I hope we will leave such medical matters to the real doctors. I could go on about Jill's talents and contributions to her many fields which include torts, healthcare law and policy, and the law of nonprofits, in which she is probably the nation's leading expert. But I choose to end my remarks by offering to you all a few short poems of mine I wrote for this occasion in the style of haiku, a form of Japanese poetry which communicates thoughts under the strict constraints of a 3-line 5-7-5 syllable form. I didn't have time to title them. So haiku number 1. Northwestern's good health, enabled by this new hire. Fruitful years ahead. Number 2, our fearless scholar, modeling innovation, writing for justice. Number 3, there's only 4, so don't worry. I know I'm not going to say it, so don't worry. Number 3, Gilles in the winter, but not of her discontent, happy in our midst. And finally, number 4, a legal prophet, deep work on the nonprofits, and we all profit. Without further ado, I give you with congratulations and a hearty mazel tov, Professor Gilles Horwitz. Too much hair.
Just don't know how I'm supposed to follow that. So, thank you, Dan. My relationship with Dan is truly emblematic of what is so exciting about being a professor, or I thought it was before about 3 minutes ago. So I met Dan online during the pandemic when I attended via Zoom a talk he gave, and I had ideas. And so I sent him some thoughts via email, and the initial emails turned into co-authorship, more plans to write, some publication, as well as becoming colleagues and dear friends. I've held several chairs over my career, and the celebrations have been rather muted in comparison to this one. Not only have the celebrations not ever included bagpipes before, but they also have not been so meaningful to me. I landed at O'Hare on what was about 4 decades to the day after I first showed up in Evanston as an undergraduate. To be honest, the nostalgic tears in my eyes that day may have partly been because O'Hare has not been updated one bit since the 1980s when I first arrived. So it was pretty easy to recall what it felt like to be a new college kid seeing Lake Michigan in the Midwest for the first time. But that wasn't the only reason. Being back at Northwestern and being honored in this way is particularly meaningful to me because this university awakened my intellectual curiosity, and it provided me with the opportunity to spend a lifetime of learning. The search for truth is really more important now than it's ever been during my career, and I'm quite honored to be doing this work here. Thank you, Dean Emerita Osofsky, Provost Haggerty, and President Emeritus Gilles for bringing me back to Northwestern. I've been lucky to have many brilliant and supportive advisors over the years, including Martha Minow, the former dean of Harvard Law School and dear friend to this law school. Martha once told me how important it is to use all the tools in the toolbox. What did she mean? There are no serious problems facing the world that can be adequately addressed by any single discipline. Clearly, Rich and Sandra Trobman understood this when they endowed the Trobman Innovation Professorship. Because I teach nonprofit law, I had to go and ask for the gift agreement, and so here's a quote from it. The professorship is meant to include a preference for a holder of the position who is an interdisciplinary scholar whose work bridges the law-STEM interface and/or helps to advance needed innovation in the law. I'm grateful to the Trobmans for their forward-thinking gift, and I'm particularly honored that Harry Osofsky asked me to be the first chairholder. As Dan explained, I've tried to fill my personal toolbox with tools from several disciplines. As an undergraduate in history, and then studying law, economics, public policy, and even a little bit of medical ethics on the side, but do not call me with your emergency, dial 911. No one person, regardless of how many years she tries to remain a student, has a big enough toolbox to solve problems alone. The chair and being appointed to both the law and the medical schools has already provided me with new colleagues, like Dr. Lori Post from the medical school, who's here today, and opportunities to think more broadly and creatively across disciplines. There are simply too many generous teachers and colleagues to mention over a long career. So as I assume this chair, I plan to thank them by doing my best to follow their lead in conducting research and mentoring others with creativity, curiosity, and integrity. Finally, many thanks to some of the people who are watching this event, my family, and those who are very dear to me, especially my friend Eric Zolt, who's spending the semester here from Los Angeles, my sister Julie, Sheldon, and others. I want to just mention my two children. My son Matthew, who is committed to a life of research, and one day soon will be wearing a silly robe like this one. And to my daughter Jane, whose creative work teaches me the importance of boundary busting every day. Thank you.
Hello. It is my very great honor to introduce you to Professor Alex Lee. It's more than an honor. It's a pleasure because Alex and I are friends. We went to law school together. Consequently, we have known each other for 27 years. And yes, to answer the question that's forming in your mind, at law school, we were the cool kids. Alex's undergraduate degree is from Harvard in mathematics, where it won't surprise you to learn he excelled, graduating summa cum laude. He completed a master's in mathematics, or as I understand it, the equivalent of such, at Cambridge University, and Cambridge awarded him a first-class distinction. He then attended Yale University for both his law degree and his PhD in economics. After graduating from law school and completing his PhD, Alex took an interesting path. He entered the SEC as an economist and embedded himself in understanding the complex world of securities regulation and rule formation. He then eventually moved on to become senior counsel on the law side of the SEC, having seen both of these critical sides. I have had kept in touch with Alex and was delighted to see that he later sought a teaching job and was hired by the University of Southern California. There, Alex embarked on a series of important and carefully executed projects, combining his unique talent, and I say unique in the strictest sense of that word. I know no one quite with Alex's background, work experience, and skills. I want to cover a couple important results from Alex's work. So first, Alex and a co-author extended a long understood result, the so-called Priest-Klein hypothesis, which held that disputes aren't randomly selected for litigation. In formalizing a mathematical model of the Priest-Klein hypothesis, Alex demonstrated that this insight, and a co-author demonstrated that this insight is indeed true, which is not so surprising. But what was surprising and emerged from the math was that you could nonetheless, under general conditions, make inferences about the effect of the change in legal rules from changes in litigation win rates, something that I think was something of a surprise to the Academy, but is now accepted. In a later paper, Alex and co-authors derived the formal conditions under which a win rate in litigation would be 50-50, which was an intuition of the Priest-Klein model, but not one that I understand had been formalized. A recent important result from Alex's work links the rise of meme stocks like GameStop to reduction or zeroing out in trading costs. But he and his co-authors find that these changes did not lead to a more beneficent form of corporate governance. And most interesting to me, and something I did not know about or hadn't read, I'd read these other papers until I prepared for today's talk, was that Alex has relied on the insights of the great Austrian economist Friedrich von Hayek to understand the limitations of knowledge within the complex administrative state, arguing more generally for a more adaptive approach to regulation, which he calls epistemological humility. Let me close by saying that when Alex visited here, I was tasked to evaluate his teaching. He visited in anticipation we would give him an offer. And I must say, teaching securities regulation is a daunting task, but it is not a thankless one. All of the faculty thank Alex for teaching security regulation because that means we do not have to. But the amazing thing is, and this is serious, the amazing thing is the remarkable job Alex does with it, which I observe firsthand. His students are very fortunate to have a professor who can take a complex, dense, and unfamiliar set of material and make it coherent and tractable. I could go further on about Alex's services to the law school, which have been executed with care and loyalty, but let me not delay. It is with this gratitude that I proudly introduce Alex Lee as a Howard Friedman Professor of Law.
Thank you, Max, for such a kind introduction, and thank you everyone for being here. Today, I am keenly aware that I am the last thing standing between the ceremony and the reception, so I'll make it very brief. One of the great perks of this great job, in my opinion, is that we have an opportunity to get to know students year after year, perhaps at their most vulnerable state, as they try to navigate law school and imagine life beyond it. Now, students often schedule office hours with me, not to ask questions about securities regulation, as scintillating as that is, but to seek career guidance and life advice. And frankly, I feel ill qualified to really offer any advice because frankly, most of them will go into private practice. I've never had such experience, having clerked as a law clerk and worked for the federal government. But what little wisdom I do share with them is the following. I tell them, whichever job you choose, you have to make sure to check at least the following 3 boxes. First, the work itself has to be intellectually stimulating, and almost everyone looks for that. And I tell them the mistake you might make is to look for only that. Number 2, you have to be able to respect and enjoy the colleagues and the mentors you work with, because these are people you see on a daily basis. They can either make or break your life, and my students understand that too. Third, this is where things get a little difficult. I tell them you must ultimately believe in the mission or the cause or the purpose of the work you do. And this is the moment at which most of them say, oh, so close. Okay, all jokes aside, I'd remind them that we human beings are inevitably creatures that seek meaning in life. And there will be moments in life when you kind of look at yourself and say, what am I doing with my life? How am I finding purpose and meaning through the work I do? Now, After I was notified that I would be bestowed with this chair, I began learning more about our distinguished alum, Howard Friedman's life, by reading about him and also speaking with those who actually knew him personally. And Mr. Friedman was someone who truly sought to check all these boxes throughout his remarkable career. He began his life as a tax lawyer, and then quickly shifted to corporate law, and rose to become a very respected attorney with countless clients, helping them with M&A and complex transactions. But that's not all. He also served in the armed forces for more than 30 years, initially as part of the U.S. Navy, and then later in the Naval Reserve, where he was a judge advocate general. But above all, he loved Northwestern and wanted to give something back to our community. Now, after learning about Mr. Friedman's career path and the tenacity and the conviction with which he pursued his passion and the fondness with which he remembered Northwestern, I began asking myself, perhaps our job as law professors is not really about teaching black letter law to our students, no matter how effectively we may do that. Perhaps our job is to actually equip them to navigate the legal profession and prepare them to lead a fulfilling life as lawyers, to raise and cultivate more Howard Friedmans of this generation. How exactly do we do that? I don't know. I'm still trying to figure out, but I'm sure the answer does not lie in more PowerPoint slides or more meticulous handouts. It may lie in our having more honest and open conversations with our students, in being willing to be more vulnerable with them, in emphasizing our shared human experiences. Which brings me to my final point. When it comes to my own job, I am incredibly fortunate to have found one that actually checks all the boxes. The work itself could not be any more intellectually stimulating. I respect the colleagues immensely that I work with. But also, importantly, I believe in the importance of the work we do at the law school to train generations of young legal minds and equip them for the future. And when thoughtfully done, this, I think, is a calling worth pursuing. It's what gets me out of bed every morning. And despite the rise of AI, I firmly believe that the human element that is so essential to this job is something that cannot be replicated. And if anything, the real challenge AI presents to us is not that we as law professors need to incorporate more AI into our pedagogy. Rather, the challenge is for us to remember to be more human in all aspects of our job. In closing, I'd like to thank Linda Friedman Meadow and Carrie Meadow for establishing the chair and for their generous support of the law school. I'd like to thank all the deans I have served, Dan Rodriguez for inviting me to Northwestern and persuading me to stay, Kim Nurako and Jim Spera for leading the law school through some of the toughest times in our recent memory, Hari Osofsky for entrusting me with great responsibility for securing this chair and nominating me to it. And of course, Zach, I really look forward to working with you for years to come. I'd like to thank all my colleagues for inspiring me to be a better scholar and all my students for inspiring me to be a better teacher. And finally, my greatest thanks go to my family, especially my wonderful wife, Emily, who is here with me this evening and who has supported me in every imaginable way possible throughout our 17 years of marriage. Thank you.
All right, that was great. And I want to thank everybody who was here today and all the people who spoke. Zach, Myriam, Paul, Jill, and Alex. Once again, congratulations on the investiture and another exciting step in your journey on scholarship. I'd also like, as provost, to say, good job, Pritzker, to getting all these people to work here. So, great is all I can say. I think everybody here has made the school proud and the university proud. And we look forward to witnessing all that you will accomplish for Northwestern in the years ahead. So now it's time to head to the Martin Atrium for the reception and to congratulate our honorees. And thank you so much and enjoy the rest of the evening.